Hi, I'm Karen Cole from Legal Minded Friends, and today's question is, when should I use without prejudice, and what does it actually mean? So I'm not going to give you a legal course on this. I'm going to give you my experience in court with this through people I have helped that were litigants in person. The legal meaning itself, without prejudice, means that you want to enter into a conversation with somebody freely, and you want to be able to speak openly and freely about offering a settlement. So if you're employed, your employer might write to you and say, can we have a meeting, a without prejudice meeting, which means they just want to be able to negotiate with you, talk with you freely, and if it ever does go to court, it means whatever you've said shouldn't really be held against you. You won't lose your legal rights, and it doesn't mean that you've actually agreed to anything. However, what you've got to be careful of is the without prejudice. If it doesn't have a direct link to the settlement itself, then the evidence within that, the other side can ask for that to be, they can ask permission from the court to be taken as evidence. Before I give you an example of something that can happen in mediation, or if you're in a settlement negotiation, you do have to be aware that if the other side has made a reasonable offer to settle and you have not been reasonable, then you could be liable for their costs. However, the without prejudice, if it's directly linked to the offer to settle, and at the time you didn't agree, because let's say the hearing came out with further information than if you would have known, you would have agreed, and the court says, okay, well, we think you were still reasonable, so they'll balance out whether or not you owe costs, because sometimes people do keep a little bit of information aside, and they only bring it out at the hearing, and you say to yourself, well, I would have settled if I would have known that. So I'm going to give the scenario where you're the person who's being sued for $10,000. So there's somebody suing you, and you've entered into negotiations, or you're in mediation, and like the court will always look at mediation as without prejudice, privilege. So, and negotiations are the same. So the other person says to you, you owe me $10,000. You say, no, I don't owe you $10,000, but I'll pay you $9,000 so that we don't have to go to court. And they say, nope, we're going to court. So you get to court, and the judge looks at all the evidence and says, you know, I don't really think you even owe them $10,000, but I think you should pay them $6,000. And the other side is like, whoa, wait a minute. They offered me $9,000 in negotiations. Shouldn't they be held accountable to that? And that is where the without prejudice comes into play, because the key is that you're in negotiations and there's a direct link to what you've offered. So, or the court could say you owe nothing. And so a lot of people get surprised at that. They say, well, wait a minute, but they offered me $9,000 in mediation. And the court might say, no, they don't owe you anything. So it just means that when it does get to court, the court won't use what you offered. If it's a direct link to the offer to settle, they won't use that against you. You don't lose any of your legal rights, and you're not admitting to the claim itself. However, if you're in negotiations and you give out some information that is, let's say, is not directly related to the settlement, so you give out other information, then the other side can ask for the court to bring it into evidence. So they will seek permission from the court to bring it into evidence, or you could decide together that you want to bring it into evidence and agree that. That's a little more difficult, a little more complicated, I mean. So, but what you want to remember is without prejudice, when you use it, you should use it at the beginning of any negotiations. I think without prejudice is overused because once you've entered into negotiations, you're always without prejudice. You're always going to get that privilege from the court. If you're in mediation, or you might have heard of a frame ADR, which means alternative dispute resolution. That's the same thing. You're still trying to settle the matter, and the court will always look at that as without prejudice. So I hope that makes it a little bit more clear and when you should use it. If you need help with a legal matter, then please contact Legal Minded Friends. We help litigants in person, and we just give legal information so that you can make the right decision for your personal needs. Okay? If this has helped you or someone else, please like and share. Thank you.